Section 109, Application of Information and Communications Technology. In accordance with international standards, the Bureau shall utilize information and communications technology to enhance customs control and to support a cost-effective and efficient customs operation geared towards a paperless customs environment. The Bureau shall communicate, exchange, and process trade and logistics-related information in the national and regional level for the efficient and prompt clearance of goods and commodities in a technology-neutral and secured infrastructure for business, industries, and government. The security of data and communication shall be in a manner that is consistent with applicable local and internationally accepted standards on information security. The Bureau shall likewise include, as part of its systems and processes, a disaster preparedness and recovery plan to ensure business continuity by maintaining its uptime goal for its electronic and online services. For purposes of customs procedures, electronic documents, permits, licenses, or certificates shall be acceptable and shall have the legal effect, validity, or enforceability as any other document or legal writing, provided that when the prescribed requirements are duly complied with, the Bureau shall a. recognize the authenticity and reliability of electronic documents, b. transmit approval in the form of electronic data messages or electronic documents, and c. require and/or accept payments and issue receipts acknowledging such payments through systems using electronic data messages or electronic documents. The introduction and implementation of information and communications technology shall be undertaken with due consultation with directly affected parties and stakeholders. Section 110, Relationship between the Bureau and third parties. Parties may transact business with the Bureau either directly or through a designated third party to act on their behalf. The customs transaction directly transacted by a party shall not be treated less favorably or be subject to more stringent requirements than those transacted through a designated third party. A designated third party shall have the same rights and obligations as the designating party when transacting business with the Bureau. Subject to the provisions of existing laws, treaties, convention, and international agreements, the Secretary of Finance shall make the necessary guidelines for the defined relationship of the Bureau and third parties.
Section 111, Information of General Application. All laws, decisions, rulings, circulars, memoranda, and orders of the Bureau shall be published in accordance with law. To foster an informed compliance regime, the Bureau shall ensure that all relevant and available information of general application pertaining to customs operations and procedures which are not confidential or intended for the Bureau's internal use only shall be readily accessible to any interested person. Any new information, amendment, or changes in customs law, administrative procedures, or requirements shall, as far as practicable, be readily available prior to its effective date of implementation unless advance notice is precluded.
Section 12. Information of a specific nature. The Bureau shall provide information not otherwise confidential or for the Bureau's internal use only, relating to a specific matter as may be requested by any interested party for legitimate use. The Bureau may require the payment of a reasonable fee in providing such information. The requested information shall be released within reasonable time from the filing that request and payment of the required fee.
Section 113, Decision and Ruling. The Bureau shall, consistent with Section 1502 of this Act, issue binding and advance decision and ruling at the request of an interested party on matters pertaining to importation or exportation of goods. Upon written request of the interested party, the Bureau shall notify the party of its decision in writing within the period specified in this Act or by regulation. Should the decision be adverse to the requesting interested party, the reasons thereof shall be indicated and the party shall be advised of the party's right of appeal. The ruling and decision shall be issued by the Bureau within 30 days from the submission of the necessary documents and information. Section 114. Right of Appeal, Forms, and Ground. Any party adversely affected by a decision or omission of the Bureau pertaining to an importation, exportation, or any other legal claim shall have the right to appeal within 15 days from receipt of the questioned decision or order. An appeal in writing shall be filed within the period prescribed in this Act or by regulation and shall specify the grounds thereof. The Bureau may allow a reasonable time for the submission of supporting evidence to the appeal.